Time top financial officer of Donald Trump's company, Alan Weisselberg, did it again, pleaded guilty to felony perjury charges in a Manhattan courtroom earlier today. He admitted that he lied in sworn testimony when asked about allegations that Trump lied about his wealth during the ex-president's civil fraud trial. This is now Weisselberg's second guilty plea. In 2022, he pleaded guilty to multiple tax fraud charges and served 3 months at Rikers. Today's guilty plea will put him behind bars again for up to 5 months. These new charges come just weeks before the ex-president is set to face trial on separate allegations that he falsified business records. Manhattan DA Alvin Bragg's criminal case.
What happened in a New York courtroom recently cut straight through the image Donald Trump has spent decades carefully constructing. And it does so in a way that is unusually hard to dismiss or explain away. This was not a political opponent speaking, not a journalist speculating, and not a critic interpreting events from the outside. This was Trump's own longtime chief financial officer, the man responsible for managing the Trump Organization's finances for decades, standing in court and admitting that he committed perjury to protect Trump. Alan Weisselberg, the person who knew the internal financial reality better than almost anyone else, pled guilty to lying under oath about Trump's inflated financial statements, and that single admission has triggered a much larger and far more dangerous question for Trump himself. Weisselberg was not a marginal figure in Trump's business world. He was the financial gatekeeper, the person who oversaw balance sheets, valuations, tax filings, and the financial narratives presented to banks and insurers. If anyone understood how Trump's wealth was represented on paper versus how it existed in reality, it was Weisselberg. When someone with that level of access and responsibility admits in open court that he lied under oath to protect his boss, it changes the entire context of Trump's legal exposure. This is no longer about abstract allegations of fraud or political claims of dishonesty. This is about a proven act of perjury tied directly to Trump's financial story. In March 2024, Weisselberg entered a New York courtroom and pled guilty to 2 counts of perjury. He admitted that he gave false testimony regarding Trump's asset valuations, testimony that was central to the New York civil fraud case against Trump and the Trump Organization. These were not minor discrepancies or technical misunderstandings. Weisselberg acknowledged that he knowingly lied on the witness stand about financial statements that were used to make Trump appear significantly wealthier than he actually was. Those statements were used to secure favorable loan terms, insurance coverage, and business advantages, and the court had already determined that they were materially misleading. The seriousness of Weisselberg's plea cannot be overstated. Perjury is not a paperwork violation or a regulatory slap on the wrist. It is a felony that strikes at the core of the legal system. By admitting that he lied under oath, Weisselberg effectively confirmed that false testimony was used to protect Trump's financial image during an active legal proceeding. The court sentenced him to 5 months in jail for that crime, meaning he will serve real time behind bars specifically because he chose to lie in court rather than tell the truth about Trump's finances. What makes this moment especially significant is that this was not Weisselberg's first criminal conviction tied to his work for Trump. He had already pled guilty to tax fraud charges related to the Trump Organization and served time for those offenses. Now, he has become a twice convicted criminal whose crimes are directly connected to his role as Trump's chief financial officer. At some point, it becomes impossible to view these convictions as isolated incidents. They point instead to a pattern within the organization, a system in which senior executives repeatedly crossed legal lines in order to preserve Trump's preferred narrative. The narrative itself is central to understanding why Weisselberg would take such a risk. Trump's business model has always depended heavily on the perception of extraordinary wealth. That perception influences everything from loan approvals to interest rates to insurance premiums. Banks lend more easily and on better terms to clients they believe are massively wealthy. Insurance companies offer more favorable coverage to properties that are portrayed as extremely valuable. Inflated asset values are not just about ego, they have real financial consequences that benefit Trump directly. According to court findings and Weisselberg's own admissions, Trump's organization systematically inflated the values of key assets on financial statements. Properties were presented as being worth far more than independent appraisals supported. Square footage was exaggerated. Development potential was overstated. These inflated numbers were then used repeatedly in dealings with banks and insurers. When those practices came under legal scrutiny, Weisselberg chose to lie under oath rather than acknowledge the reality of how those numbers were generated. That choice tells us something critical about the culture inside Trump's organization. This was not a rogue employee acting on his own initiative. This was the chief financial officer, someone whose job required accuracy and integrity. deciding that protecting Trump's image was more important than telling the truth to a court of law. When the person responsible for financial truth decides to commit perjury, it raises the unavoidable question of whether dishonesty was an exception or an expectation. This is where the focus inevitably shifts to Trump himself. Weisselberg's guilty plea does not directly accuse Trump of perjury, but it places Trump's own sworn testimony under an entirely new and much harsher light. Legal analysts have begun re-examining Trump's depositions, trial testimony, and sworn statements across multiple cases, and the same pattern keeps emerging. Trump frequently makes claims under oath that do not align with documentary evidence. He overstates his wealth, minimizes his knowledge of questionable practices, and contradicts prior statements when confronted with inconvenient facts. Judges have noticed this pattern over the years. In several cases, they have expressed skepticism about Trump's credibility and, in some instances, imposed sanctions or issued rulings that reflect a lack of confidence in his truthfulness. In the New York civil fraud case, the judge found that Trump and his organization engaged in persistent and repeated fraud. While that ruling focused on civil liability rather than criminal perjury, it established that the financial statements at issue were deliberately misleading. Weisselberg's perjury plea now confirms that false testimony was used to defend those same statements in court. The danger for Trump is that perjury is one of the simplest crimes for juries to understand. It does not require complex explanations of financial instruments or legal technicalities. Perjury comes down to a basic question. Did you knowingly lie after swearing to tell the truth? If prosecutors can demonstrate that Trump made false statements under oath that contradict clear documentary evidence and that he did so knowingly, the legal consequences could be severe. Unlike civil penalties or fines, perjury convictions can carry substantial prison sentences. The broader implication of Weisselberg's plea is that it opens the door. It establishes that people within Trump's inner circle were willing to commit serious crimes to protect him. It weakens any argument that misleading testimony was accidental or the result of confusion. When the CFO admits that lying under oath was part of preserving Trump's financial story, it becomes much harder to argue that Trump himself was simply mistaken or unaware. The foundation has been laid for a much more dangerous line of legal inquiry. This development also strikes at one of Trump's most powerful political assets, his brand as a straight talker. Trump has long cultivated the image of someone who may be abrasive or controversial but is fundamentally honest with his supporters. That image is difficult to reconcile with a business operation in which senior executives admit to lying in court to maintain a false narrative. The contrast between the public persona and the courtroom reality is becoming increasingly difficult to ignore, and it is precisely that contradiction that makes this moment so significant. To understand why this moment is so dangerous for Trump, you have to look closely at how perjury functions inside the legal system and why Weisselberg's admission changes the stakes entirely. Courts rely on sworn testimony to establish truth. When someone raises their hand and takes an oath, the entire process assumes that what follows will be honest. Once it becomes clear that a key witness lied under oath, everything connected to that testimony becomes suspect, including the credibility of the people that witness was protecting. In this case, the person Weisselberg was protecting was Donald Trump himself. Weisselberg's plea makes it clear that false testimony was not accidental or the result of confusion. He did not say he misunderstood the questions or misremembered details. He admitted that he knowingly lied. That distinction matters because it demonstrates intent. Intent is what separates a mistake from a crime. When a jury hears that a chief financial officer intentionally lied under oath about asset values, they are not just hearing about one man's decision. They are hearing about a system that rewarded dishonesty when honesty threatened the narrative. Trump's sworn testimony now sits inside that context. Over the years, Trump has testified under oath in depositions, trials, and sworn statements where he made definitive claims about his wealth, his assets, and his knowledge of financial practices. In many of those instances, documents later contradicted his statements. He claimed not to know details that records showed he approved. He described asset values that did not match internal calculations. He minimized involvement in decisions that emails and paperwork tied directly to him. On their own, each discrepancy could be dismissed as exaggeration or memory lapse. Together, they form a pattern that prosecutors pay very close attention to. Judges have already signaled discomfort with Trump's credibility. In civil proceedings, courts have noted inconsistencies and rejected explanations that relied heavily on Trump's word alone. The New York civil fraud ruling explicitly stated that Trump's financial representations were not merely optimistic estimates, but part of a sustained pattern of deception. That ruling did not require proving perjury, but it laid out a factual foundation that now becomes much more significant in light of Weisselberg's guilty plea. Perjury is especially dangerous because it strips away complexity. Financial fraud cases can be difficult for jurors to follow. They involve numbers, valuations, accounting principles, and legal nuance. Perjury, by contrast, is straightforward. The jury compares sworn testimony to evidence and decides whether the witness knowingly lied. If prosecutors were to pursue perjury charges related to Trump's testimony, they would not need to explain every detail of his business empire. They would only need to show that he said something under oath that he knew was false. Trump's legal team would almost certainly argue that any false statements were the result of belief rather than intent. They would say Trump genuinely believed his properties were worth what he claimed, or that he relied on others to provide accurate figures. They would argue that exaggeration is not the same as lying. Those defenses can work in some cases, but they become weaker when paired with evidence that the organization's top financial officer knowingly lied about the same issues. When the person responsible for the numbers admits he committed perjury, it becomes harder to argue that everyone else was acting in good faith. The Weisselberg plea also exposes a deeper cultural problem. Organizations take cues from their leadership. If executives believe honesty will be punished and loyalty will be rewarded regardless of legality, behavior follows that logic. Weisselberg did not benefit personally from lying under oath in the long term. He went to jail. The benefit was preserving Trump's image and protecting the organization. That suggests an environment where maintaining the narrative mattered more than complying with the law. This is why legal experts see this as more than just another bad headline for Trump. It is evidence that the mechanisms used to protect him involved criminal acts at the highest levels of his business operation. It reframes Trump not as a passive beneficiary of others' misconduct, but as the central figure around whom that misconduct revolved. Whether prosecutors ultimately bring perjury charges against Trump or not, the existence of this record permanently damages his credibility in any legal setting. At a minimum, it ensures that every future statement Trump makes under oath will be scrutinized with extreme skepticism. Judges, prosecutors, and juries now have documented proof that truth inside Trump's organization was negotiable when it conflicted with image. That reality does not disappear, and it will shape how every remaining legal battle unfolds. What makes this situation even more dangerous for Trump is the way perjury exposure intersects with his existing criminal and civil cases. A defendant facing multiple legal battles can sometimes compartmentalize them, arguing that each case is separate and should be judged on its own facts. Perjury breaks down that separation because it speaks directly to credibility, and credibility follows a defendant into every courtroom. Once a court formally recognizes that a person has a pattern of giving unreliable sworn testimony, it changes how judges evaluate arguments, how prosecutors frame charges, and how juries perceive explanations. Trump's legal history already contains warning signs in this area. In several proceedings, courts have limited the weight given to his testimony, favoring documentary evidence instead. That is highly unusual for a party in his own case. Courts generally presume that sworn testimony deserves consideration unless there is a reason not to. In Trump's situation, judges have repeatedly found reasons to doubt. The Weisselberg plea does not exist in isolation. It reinforces those doubts with a criminal conviction tied directly to Trump's core financial narrative. The political implications are just as serious. Trump has built a public identity around strength, wealth, and authenticity. His supporters see him as someone who cannot be controlled by institutions and who speaks plainly, even when it causes controversy. Courtroom reality tells a different story. It shows an organization that depended on exaggeration, misrepresentation, and now admitted perjury to maintain that image. For voters who value honesty as a form of strength, that contrast is deeply damaging, even if they remain loyal on policy grounds. Another factor that cannot be ignored is cooperation. When a witness pleads guilty, prosecutors often require truthful cooperation as part of the agreement. That means Weisselberg is no longer defending Trump. He is protecting himself by telling the truth as prosecutors define it. Anything he says must align with documents and evidence, or he risks violating his plea agreement. That creates a serious risk for Trump because Weisselberg knows where the discrepancies are and where Trump's public statements diverge from internal records. Even if prosecutors choose not to charge Trump with perjury directly, the information Weisselberg provides can be used in other ways. It can strengthen existing cases, undermine defenses, and justify harsher sentencing arguments. It can also influence judicial discretion in ongoing proceedings. Judges consider patterns of behavior when deciding issues like credibility, sanctions, and remedies. A proven culture of dishonesty weighs heavily in those decisions. There is also a long-term reputational effect that no appeal can erase. Court records last forever. Future historians, journalists, and investigators will not look at Trump's wealth claims through the lens of campaign rhetoric. They will look at sworn testimony, guilty pleas, and judicial findings. Weisselberg's perjury conviction becomes part of that permanent record. It ensures that Trump's financial legacy will always be viewed through the question of what was real and what was invented. This is why legal analysts describe the perjury issue as uniquely corrosive. Financial penalties can be framed as business disputes. Civil judgments can be dismissed as political. Even criminal convictions can be spun as persecution. But perjury is different because it attacks the idea that the speaker deserves to be believed at all. Once credibility is gone, every defense becomes weaker, every explanation becomes suspect, and every future statement is met with doubt. Trump's remaining legal strategy will likely focus on delay, appeals, and public messaging. Those tools can be effective politically, but they do not erase sworn testimony or guilty pleas. They do not change transcripts. They do not remove admissions from the record. Weisselberg's plea is now part of the legal reality Trump must navigate, regardless of how aggressively he attacks the system around him. What we are witnessing is not just another chapter in Trump's legal saga. It is a structural collapse of the credibility that once shielded him. The idea that exaggeration was harmless, that deals justified the means, and that truth was flexible has now collided with the immovable standards of a courtroom. And once that collision happens, it cannot be undone. The most important question now is not whether Allen Weisselberg lied under oath, because that has already been answered by his own guilty plea, but what his admission reveals about the environment in which those lies occurred. Perjury does not happen in a vacuum. It happens when a witness believes the truth is more dangerous than the lie, and that belief usually comes from pressure, expectation, or loyalty to someone more powerful. In this case, the person being protected was Donald Trump, and the subject being protected was the financial mythology at the center of his public identity. What makes this situation especially damaging is that the false testimony was not about minor details or technical errors. It was about asset values, net worth, and financial representations that were repeatedly used to secure favorable treatment from banks and insurers. These were foundational claims, not peripheral ones. When Weisselberg admitted he lied to preserve those claims, he effectively confirmed that the story of Trump's wealth required deception to survive legal scrutiny. That reality reshapes how every prior sworn statement by Trump is viewed. From a legal perspective, this places Trump in an extremely vulnerable position. Prosecutors do not need to prove that he invented numbers personally to establish perjury exposure. They only need to demonstrate that he knowingly affirmed false statements under oath. Sworn testimony that contradicts internal records, especially when supported by a cooperating witness who managed those records, becomes exceptionally difficult to defend. Even if criminal charges never materialize, the existence of that exposure weakens Trump in every ongoing and future legal battle. There is also a broader institutional consequence. Courts depend on truthfulness to function. When powerful figures are shown to benefit from lies while others take the punishment, public trust erodes. Weisselberg serving jail time for perjury raises a fundamental fairness question that cannot be ignored. If the person who executed the lie is punished, what happens to the person who benefited most from it? That question will continue to hang over every proceeding involving Trump, regardless of the outcome. Politically, this moment undermines one of Trump's strongest emotional appeals. His image as a self-made billionaire who succeeded through instinct and toughness has been central to his influence. The revelation that this image required sworn falsehoods to sustain it reframes that narrative entirely. It suggests not dominance over the system, but dependence on deception within it. That shift may not immediately change the minds of his most loyal supporters, but it matters to undecided voters and institutions that still rely on credibility as a standard. Looking ahead, the consequences of this moment will unfold gradually rather than explosively. There may be no dramatic arrest tied directly to perjury. Instead, there will be quieter effects, judges weighing testimony differently, prosecutors crafting arguments with greater confidence, and defense strategies constrained by an ever-expanding record of contradictions. Each new development will be interpreted through the lens of what is now known. That truth inside Trump's organization was negotiable, even under oath. This is why the Weisselberg plea matters far beyond one courtroom or one sentence. It exposes a system that prioritized image over accuracy and loyalty over legality. It shows how fragile that system becomes when one insider finally admits the truth. And it leaves Donald Trump facing not just legal risk, but a crisis of credibility that no appeal, campaign rally, or media attack can fully repair. In the end, this is not just a story about finances or false statements. It is a story about power and accountability. It asks whether the rules apply equally to those at the top, and whether the truth still has weight when it threatens the most carefully constructed narratives. That question remains unanswered. But one thing is clear. The moment a chief financial officer admits he lied under oath to protect his boss, the foundation of that boss's defense is permanently cracked.